Okay, so what I'm looking at is the Ocmulgee National Monument, Creek Indian Land Cessions. And in this document, it talks about the Treaty of Washington of 1832. Now, we all know that everyone had a choice to either remove or to stay. Well, those under the Lynn-McGee land grants were the ones who stayed. And it states here, as you can see on this map, under the Treaty of 1814, these were the lands that were recognized under that treaty. However, I'm going to find the 1817. Come on. Here we go. Right here. By Act of Congress approved March 3rd, 1817, a method was providing for the location of these reserves. By Act of February 20th, 1819, the President was authorized to purchase these reserves whenever the reserve should desire to sell. Okay. Now, there was some issues, things that I had things that I had heard through the grapevine. Everybody kept saying Lonnie, which is my great-grandfather, Chief Fred Walker's son, my grandfather's second to the oldest brother. After the oldest brother had passed away, Lawrence, that Lonnie had sold the lands. Well, let's take a look at Fred Walker's probate. Not there. Here we go. Fred Walker's probate. This was after the lower court of Alabama, Escambia County, had heard the case and ruled with Lula Walker, the wife of Chief Fred Walker, could sell her dower interest to the remaining heirs, which were her children, Fred Walker's children, including my grandfather, could sell her dower interest to the remaining heirs. And as you see, Calvin McGee versus Lula Walker decided in the lower court, and then it was taken on appeal to the Alabama Supreme Court, and it was decided October 16, 1958, and this is certified by the Alabama Supreme Court Law Library. And here is the file that I received under certification. See if I can blow this up some. Or not. Let's download it. And I've had a few attorneys take a look at this, And I'm not happy with the opinion that I was given by a particular attorney, because he claims that what he sees is that there was a sale of the lands at a public outcry. And that's not what the case is about at all. It was not to sell the lands at a public outcry, but it actually states this was a suit in equity to set aside the homestead and dower interest of widow of deceased owner of land, and to sell for division among joint owners or tenants in common, subject to rights of widow. It was not to sell the lands at a public outcry. It was to sell the dower interest to the remaining joint owners, the tenants in common, which were Fred's children. It was stated that the appellants failed to comply with the Supreme Court rule that so-called points of law in brief were so jumbled as to make them well nigh impossible of separation and application to any of the claimed 18 assignments of error. Such assignments of error were waived and could not be considered by the Supreme Court. Supreme Court may condone noncompliance with Supreme Court rule respecting briefs when the record is short and simple, and when a strict compliance with the rule is not essential to an understanding, and the assignments of error which are argued in the appellant's brief. Tenancies in common. In action involving right of heirs of deceased owner and their mother to sell the property for division among themselves, as against purported co-tenants of the property, the remaining heirs of Lynn McGee. Evidence was sufficient to support trial court's conclusion that the deceased owner and his heirs adversely held land for the prescribed period against those who claimed as co-tenants under the patent of Lynn McGee. So the possession of co-tenants may be so open and notorious in its hostile and exclusiveness as to put the other tenants on notice, thus permitting one co-tenant to acquire title by adverse possession as against other co-tenants. So Lenore Thompson, which also represented the petitioners in the the Indian Claims Commission judgment awards for docket 21, 275 and 272, it shows that he represented those claimants as McGee et al. So what was this all about in the probate? Okay, it shows that the administrative error after the patent had been issued in 1924, that somehow the lands were taken out of trust and assessed for taxes to owner unknown. And whenever Fred had seen that he was living on the property, all the children were living on the property in 1933, once he realized that the title was purchased by Lucille Z. Moore and Charles Bates Moore, he went in and quitclaim deeded the title to the lands in his name, which were in his name already under the patent. He took back over the lands. Well, since even the Alabama Supreme Court ruled here, The prayer is that the lands be sold for division among the said joint owners, subject to the right of the widow. This appeal is brought by some of the respondents, presumably the heirs of Lynn McGee, other than the children of Fred Walker. Since there appears to be no controversy among the 11 children and widow of Fred Walker as to title to the land and sale thereof for division from a decree granting the relief prayed for. Well, the relief that was prayed for is misconstrued because it specifically states that the widow wanted to sell her share to the remaining heirs. And that's what it was about. It was not to sell the lands for division and to sell the lands outright. Otherwise, the lands would have been purchased by the president under the Act of 1817. So, with the documents that were provided, and here it shows that Fred was It says, from the portion we gather, appellants insist to be that since Fred and his children are heirs of Lynn McGee, their possession of the land was as tenants in common with all the other heirs of Lynn McGee, and that such possession was not adverse to said other heirs. If this is a question presented, it is our view that it is without merit. We have held that the possession as co-tenants may be so open and notorious and hostile and effective or exclusiveness as to put the other tenants on notice, thus permitting one co-tenant to acquire title by adverse possession. All Fred did was stood up and filed claim by quitclaim deed that this was his land under that Indian fee patent from 1924 that resulted from the land grants issued under the 1817 Act, resulting from the 1814 Treaty of Fort Jackson. We go back. Let's pull up the audio. No. I'm going to pull the record from the clerk. Let's see which one this one is. So what I received from the clerk regarding the lands, here is a quitclaim deed for Fred in March of 1938, where he purchased it for a sum of $100 from Lucille Moore and C.B. Moore, north half, southeast quarter, section 28, township 2, north of range 5 east. Okay, and of course, here is where they purchased it off the county court steps in 1933. Assessed for taxes to owner unknown, because the Bureau of Land Management, for whatever reason, I guess whether it be I don't know, for whatever reason, in 1924, sending the Bureau of Land Management records down without the owner's name. Here we go with the administrative error. So this is the administrative error for selling the lands on the county court steps. These should have never been assessed for taxes. North 1/2, Southeast 1/4, Section 28, Township 2, North Range 5 East. Okay. And then oh, okay. Let's go to title search. So in 1985, the lands went into trust for a second time, where deed handler for Porch in the bureau had emailed me after a discussion regarding this property. Had emailed me, says Miss Walker, I've attached copies of several documents and maps for your information. Hopefully you'll find them useful. The first is fee patent from the U.S. to the heirs of Lynn McGee for 319 acres of land, part of which is subject to your inquiry, the North 1/2, Southeast 1/4, Section 28, Township 2, Range 5 East, with highlighting added. I've also attached very rough plats of North 1/2, Southeast 1/4, Section 28, just to give you an idea of where it lays in relation to the other tribal trust property. Oh, my children. Also attached is a copy of the deed accepting the aforementioned property into trust for the Porch Banner Creek Indians. I see from the court case you sent for Calvin McGee versus Lula Walker that the land was quieted in the name of your great-grandfather, Fred Walker. However, the land was apparently purchased from the Pensacola Loan and Savings in trust for the Porch Band of Creeks Indians in 1984. Okay, so it was found in the Pensacola Loan and Savings in trust for the Porch Band of Creek Indians in 1984. I suspect the bank acquired the land through foreclosure, but without an abstract of title, I can't be sure. So that just admitted that the Bureau of Indian Affairs, Bureau of Land Management, never did an abstract title search on the property when they took it into trust in 1984. Had they have done an abstract title search, they would have connected the docket 272 sharers that were recognized under the Act of 1817 with the land location registers with the open IIM accounts to the title of the property. This is where Congressional Act recognized title holders. We still had that government-to-government relationship. And without an abstract title search, that was in violation of the regulations of taking lands into trust. So here's the patent. And this was 1924, November of 1924, where in the probate, this land is mentioned. And then here's the deed that was taken into trust. I'm going to download it so you can see it better. So here's the deed when it was taken into trust in 1984. north half, southeast quarter, section 28, township 2, range 5 east, containing 80 acres more or less. And from the Pensacola Loan and Savings, November 13th, 1984. Signed by the Executive Vice President. Pursuant to the authority delegated, the BIAM, Section 5, the Act of 1934. The deed is hereby approved and accepted by the Secretary of the Interior. Acting Area Bureau of Eastern Area Director Bill Ott, November 13th, 1984. Okay. So when I had the clerk pull the records of anything that she could recognize marked here, I never received the actual documents that were attached to this. But I recall that the clerk said that the name attached to this was Dunn, D-U-N-N, and there was a bastard child also connected to this. Now, let's go back. And I want to pull up, since there was no abstract title search done on the property when it was taken into trust, I requested a title search from a gentleman that worked in real estate agency that did closings. To explain to him what I needed and why I needed it, the gentleman did it for free for me. And he went back in the public records, in the archives of Escambia County tax records. And what he found, let me find it, was pretty interesting. Because something doesn't add up here. Let's just open it. Excuse me. Okay. So here's the abstract title search. He went back as far as he could possibly go. And as you see, it's tax year 2015. All right. So here, the tax year of 2015 has the land description showing that it is Indian reservation and what all is on this property. And he said that he went back as far as he could possibly go, and that was 1966. Nothing before 1966 was accessible. I did contact the tax collector and the tax assessor and requested to receive any of the archived documents, tax deed, tax records for payments on the property prior to 1966. However, I was denied access after going before the committee requesting access to the documents that were housed in the annex building. Denied access, and after 2 years of putting in my initial request for them to go into the archives themselves and pull any tax payments that they could find on the property, they still have not fulfilled that request. So, and I do have emails confirming that statement where I've requested and have been denied access to these records. So here's the warranty deed found in the will of a gentleman by the name of Carl Slaughter. Now, Carl Slaughter, if you do some history on this man, he actually had owned the same property of Fort Mims. His daughter is in charge of the Fort Mims I'm not sure what you would consider it, but she's in charge of something over Fort Mims. Anyways, he owned Fort Mims property. So here it says that Carl Slaughter had, in probate, left the property. Hold on. Will of Carl Slaughter, which was admitted to probate and record in the public court or probate court of Baldwin County, 1966, and which empowered the executors thereof to sell the property of said descendant at public or private sale. June Slaughter, a widow, devised under said will to grant, bargain, sell, and convey to John L. Moore and Laura M. Moore for and during their joint lives and upon death of either of them. Okay, so it went to the Moores, and here is the property. And then here let's see. All right. Together in every contingency, having a hold. We do in ourselves and heirs, executor, administrator, convent with said grantees, their heirs and assigns that we are lawfully seized in fee simple of said premises, that they are free from all encumbrances, that we have a good right to sell and convey the same. And we shall, in our heirs, executors, and administrators, shall warrant and defend the same lawful claim, hands and seals. And as you see here, it's signed by Robert Leslie Smith. Okay, June Slaughter. But pay close attention to Robert Leslie Smith now, and how he actually ties in to this property under the will of Carl Slaughter. Okay? Now, from Carl Slaughter and Robert Leslie Smith, okay, last will and testament, there's the deed. Okay, so then says that John L. Moore and Laura Moore, also known as Laura Moore, called grantor for $1 in hand by Charles Bates Moore, Jr., herein called the grantee, the receipt whereof is hereby acknowledged, do grant, bargain, sell, and convey unto the grantee the following described property. So Charles Bates Moore, the son of Lucille Z. Moore and Charles Bates Moore from 1933, who purchased the property on the county court steps, ends up with the property. In 1973. Okay? And look, John L. Moore and Laura M. Moore. There's the deed. And then Charles Bates Moore Jr. and Lucille J. Moore, herein called grantor, the sum of $1 in hand paid by John L. Moore Jr. Same property. By fee simple, Charles Bates Moore Jr. and Lucille J. Moore. And look at this. It's notarized. Let's get a little closer. It's notarized in the state of Oklahoma by Melba A. Pearson, Charles Bates Moore Jr., and wife Lucille J. Moore. 5th date of July, 1975. Okay. Here's the warranty deed. But then it goes from the person who sold the property to Charles Bates Moore Jr. and Lucille J. Moore in 1970, what was it? July of 1975. It then goes into a foreclosure from John L. Moore Jr. and wife Pat H. Moore into Artex Enterprise, Inc. Assumed because of a foreclosure. So they seized in fee simple the premises. August of 1975. August 14th of 1975. Here's your quick claim deed. And somewhere along this, the tax assessor, Mr. Thad Moore, acknowledged that his name is on this document, but swore to me that it was not him, that he had nothing to do with this. And I'm kind of finding it odd that the tax assessor's last name is Moore, and his name is on it, and he has nothing to do with it. So here, now in 1977, after the foreclosure going into Artex, it goes Okay. Default of payment in debt on a mortgage. Goes into 1977 into the Pensacola Loan and Savings. James E. Hart Jr., auctioneer, Pensacola Loan and Savings, and the amount of $250,000, which sum of money offered to credit of indebtedness secured by said mortgage property. Pensacola Loan and Savings. Robert G. Barr, Vice President. And yet, let's see, and there's the probate office, Escambia County, Alabama. And this is where it goes into trust for the Porch Band of Creek Indians. Signed by Bill Ott. And this is where it was recorded. November of 1984. But of course, on the deed, it doesn't go back to the original patent holder, which was Fred Walker, nor the original quitclaim deed that would have fallen under the 1934 IRA, because there was no abstract title search done on the property. In order for it to connect to the Docket 272 sharers who received the title under the 1817 Act, who received payment for the damages to the property. Interesting, huh? So there you have it. The issues of the lands resolved.